Boker Tov, so yesterday we talked about the concept of ownership of Hametz, and we concluded, based on the words of the Hachamim and the Halacha, that it's about ownership. Even if a person has Hametz in their home, as long as they don't own it, and there is a way of preventing access, it's permissible. If a person owns Hametz, regardless of where it is in the world, it's a problem from the Torah to own Hametz. And so the question which now needs to be thought about is with regards to shares. A person who owns shares in a company which trades with Hametz, in a supermarket, in any kind of shop which has Hametz, how do we view the ownership of those shares over Pesach? Is the shareholder a partner in the Hametz, in which case the company's assets belong to the shareholders and there's a problem of owning it? Or is he just a creditor and therefore he is allowed to have that, own the shares over Pesach? So this question was put forward to Rabbi David Hoffman from about 150 years ago in Germany. And he wrote in his Teshuvah that actually this question was posed as an exam to the students in the Bet HaMidrash, seemingly in their Smicha exam, and the answer was to be lenient, and he wants to explain why. And this was discussed beyond him as well, and essentially what comes out from the poskim is as follows. The Gemara discusses a case in which the Hametz is in the mouth of a snake. You own Hametz, and that Hametz is now in the mouth of the snake. The Gemara discusses whether there is a duty to get rid of the Hametz. Do you need to bring a snake charmer to go get rid of it and dispose of it, or can you assume that it's fine, it's gone, it's in the mouth of the snake? And the understanding behind that is that since I don't have access to it, although it still technically belongs to me, the Hametz, but I have no access of getting it because it's in the mouth of the snake, therefore I don't have an issue with that, even though it still technically it's owned by me technically, and theoretically speaking, if someone was to come at the spur of the moment and somehow take it out of the mouth of the snake, it would return back to me. But practically speaking, I have no access to it, and therefore there's no issue of owning that Hametz because it's in the mouth of the snake. And so essentially the same idea is put forward with regards to shares. If a person doesn't have a say in the voting or the management of the company, and he's merely a shareholder without any practical involvement in the shares, then this is perhaps comparable to that, in that you have no access to it. Of course, you can sell the shares, but in terms of practical access to what's in the Hametz itself, there isn't really access to it. And therefore, in that sense, the majority of the poskim conclude that provided the person doesn't have a significant share in the company in terms of management, in terms of deciding how to invest the funds and so on and so forth, it's very insignificant. Then, on that basis, a person can be lenient and assume that there's no issue in owning the Hametz. If a person does have let me say one further point, is that some of the poskim were concerned with this, and therefore they said to sell it with the selling of Hametz, which some people do before Pesach. Sell it to a non-Jew so it's no longer under your ownership. And that has its own issues. But since anyway, Meikar Hadin, many allow it to be permissible, therefore if one wanted to add it into the sale of Hametz, then okay, that's fine. But if a person does have a significant shareholding in a company which trades with Hametz on Pesach, then that's a much more serious issue. And that needs a person to seek rabbinical advice as to how to go about it. And just saying to sell it isn't so straightforward, because since he has a significant amount, selling shares on isn't like selling food. It's more complicated and needs more thought. And so in conclusion, with regards to shares, if a person just owns shares and doesn't have a significant role in the company, that's fine. It's good to sell it if you wish to. But if a person does have significant shareholding, and Moshe Feinstein said 30% and above, then that's more of an issue, and that needs to be dealt with.